Connected. We are live streamed. All right. We are live. All right. So my name is Chris Perry, certified LLA attorney and certified financial planner with Castle Wealth Group. And we do these weekly wisdom webinars every Wednesday, unless I'm traveling or something. So they're pretty regular. They're unscripted. There's no PowerPoints or anything. It's just answering questions that people submitted either throughout the week or while we're live on the call. And it lasts as long as there's questions. So if you do have a question, put it in the Q&A. And I always like to start with a positive focus, just something positive that happened over the previous week. And a lot of times it's family related. It's back to soccer season, and my son's team, we're now playing 11v11, and we only have like 13 players on the roster. So we're shorthanded, and probably will be shorthanded for a number of games. But it was great. We won 3-0. Not only did my son play well, but who's 12, but my 9-year-old daughter also played just because we needed some players. She plays on a select travel team, so she held her own out there. But yeah, it was great to get a win for our first game. So that's my positive focus. Now let me share my iPad. Hit that button, that button. And there we go. All right, so I should be seeing my screen. Good. All right. Okay, so a question that was submitted, kind of a long one, but I think it's a good one. So we have parents, let me move this out of the way, I can read it up there. So parents have 5 kids, one has special needs, that's something important. One has issues with money. Okay? The other 3 are stable. Parents are looking to put money away for the special needs child. But bank accounts and maybe homes have been put in the other 3 kids' names. Now, if you submitted this, is it joint or is it supposed to be going to the kids upon parents passing? That's going to be important to know. And the idea is that the 3 stable ones will take care of the 2 that have issues. So is there a type of trust where one kid could manage everything for the 2 that may need help? When the special needs child passes, can the money go to the surviving 4? Is there a tax issue putting it into the other kids' names? To answer your question, yeah, this is why, one of the big reasons why we do trusts for these specific reasons. Like, and think of a trust kind of like a suitcase. While you're alive and well, you're holding on to the suitcase, and then when you pass away, everything that's in that suitcase, so assuming the trust was funded properly, the successor trustee can then distribute the assets wherever they're supposed to go. And typically with a trust, what we see is upon death, it might go outright. So we call that the pillowcase of money approach, or we might build in some protections where it's held in trust. And there's different ways that we can do this. So a lot of times we might have like outright distributions once the kids reach a certain age, maybe 25 or 30 or 35, with the idea that you're protecting kids from their own poor financial mismanagement. But most of my clients feel comfortable with their kids, and so they'll leave it to them still in trust, but by leaving it to them in trust where they could actually be the trustee of their own trust, everything inside of the trust could be protected from divorces, creditors, bankruptcies, etc. And so if we had one trust, it could then split into 3, 4, or how many? We have 5 kids here. So it could split into 5 separate shares. You know what? Let me just draw this bigger. So what we could do here is, get rid of this too. So if we have one trust, and then with a trust, there's different roles. The first role is a trustee. And then you have what's called beneficiaries. Trustees, who's in control. So typically it's the parents while they're alive. Sorry, I missed your question about the bank and home. The question I had is, are the kids on the bank or the real estate now, or is it supposed to go to the kids when mom and dad dies or when the parents die? Because that's going to, I'm going to give you a different answer based on how that gets answered. But getting back to my explanation of trust, there's the role of the trustee. So that's the person in control. Typically, that's the person who creates the trust. And then you have a successor trustee, and then you have the beneficiary who receives the benefit of the trust. So in this situation, here's the parents. The parents set up this trust. They're the initial trustees of the trust. And then we have a five-way kind of split or distribution here upon death. And so each kind of separate share could be handled differently. So maybe this is a special needs trust, and maybe one of the other kids is the trustee of that trust, one of the stable kids. Then we have the one that has money issues. This could be what we call a discretionary trust, where someone else manages it. So it's a discretionary trust. Similar to how you would set it up, like my kids are 9 and 12. I wouldn't want the money going outright to them. I'd want someone to manage that, have discretion. You make sure the money's used for good things, like maybe a down payment for a home or something, or braces, things like that. And then the other 3 distributions, we could either just go outright, so that pillowcase and money approach, or we could leave it to them in trust, where there could be the trustees of their own separate share trust. So yeah, to big picture, to answer your question, yeah, a trust would be the route that you would want to go with this. And just the kind of distribution pattern might be different for the different beneficiaries. In our office, we call kind of these provisions here, when we're not going outright, we call these like legacy provisions. So this is where you're protecting the legacy versus just going outright distributions, just basic kind of outright. And so in our office, it's kind of different levels of planning. All of this would be legacy type planning. If we just said outright to the kids, that would be just outright distributions. Now, to get to the second piece of this, bank accounts and maybe homes have been put in the 3 kids' names. If there's parents already and they've distributed the assets to the 3 kids, I'm not a big fan of that. So maybe they gifted already? They gifted to the other 3 kids. That's generally not the best way to handle it. Maybe you're talking about they added the kids jointly. That's also not a good way to do it. I'm not a big fan of, 2 things I'm not a big fan of is gifting and adding kids joint. These are both big no-nos. Gifting, you create some Medicaid issues, like if mom or dad were to need nursing home care in the future. Plus, I want mom and dad always to be in control. And so if they gift the assets to the kids, they're not in control. Also, now if they gifted outright to the kids and one of the kids goes through a divorce, a bankruptcy, a creditor action, a lawsuit, they might lose that piece of real estate or that account. So you're opening yourself up to a bunch of liability by gifting to the kids. Similarly, by adding the kids joint to a piece of real estate or a bank account, if one of those kids gets a divorce, a lawsuit, creditor action, bankruptcy, that account could be lost, versus keeping it in the parents' names and then leaving it to them in trust. That's going to build in protections. Also, maybe we want to build in asset protection for your parents too, where we would set up an asset protection trust called a castle trust that would protect them from creditors and lawsuits and nursing home care for themselves. So yeah, so if this were my client, what I would recommend is that we set up a trust. We would have mom and dad as the initial trustees of the trust, and then one of the 3 stable kids would be the successor trustee. Their job would be to wrap up the final affairs of mom and dad, pay all the bills. And then once that's handled, then it would be a 5-way distribution. One leg of the trust would be a special needs trust. One leg of the trust would be a discretionary trust. And then for the three other children, it would be just a decision of, do you want to give them the opportunity for a lifetime of asset protection where they could each manage their own separate share trust? Or do you want to just, in kind of protecting that legacy, or do you want to just basically give it to them outright? So seems complicated, but it's something that we regularly do, basically daily. Not always like special needs trust or discretionary trust, but this would be the route that we would go. Is there a tax issue? Let me just kind of finish this up. Is there a tax issue by putting the other kids' names on it? One of them is you lose step up in basis when mom and dad die. Yes, as beneficiaries, I believe, no signing powers. Gotcha. Okay. So they aren't added joints, but they're listed as beneficiaries on these things. I still have a problem with that. I would just set it up in the trust, and the other three kids could be the trustees to manage the money for the benefit of the other two. If you're to name them joint, then you get step up and basis issues, and that's kind of messy from a tax perspective. Is there a tax issue by putting it into the kids' names? So if the kid were to inherit it, but he or she's going to kind of give the money to the special needs child, you could run into some gifting issues again. Again, a trust, setting up a trust and making sure that it's created correctly and it has the right language is the route that I would go, because it's creating a rule book. And so mom and dad can create this rule book that has to be followed by the successor trustees versus just giving things to the other kids. They can do whatever they want. Plus, there's liability questions too, where if, let's say we give it to the three kids for the benefit of the other two, if one of those three kids gets a divorce, lawsuit, creditor action, bankruptcy, now it's lost, versus if they were serving as a trustee of the trust, it would be protected. So there's a variety of reasons why setting up a trust, making sure to go to attorney that understands the special needs concept and the discretionary trust is what I would recommend. There's a lot in that one. Yep. Okay, let me see. What other questions? Any other questions? That one was all submitted. All right, let me see. Any other questions? All right, that might be it for this week. All right, that's it. Take care. Thank you. Bye-bye. Bye. Bye-bye.